In marijuana news, a federal agency has suggested that marijuana should be moved to Schedule 3 in the Controlled Substances Act from its current position as Schedule 1. A long overdue change, in my humble opinion. So it looks like maybe, possibly, there might be finally some sanity when it comes to the status of marijuana under federal law. So let's learn a little bit more about this. The United States Department of Health and Human Services is officially recommending that marijuana be moved from its current Schedule 1, where it is the most restricted category of drug, to Schedule 3. An historic development that means the top health agency no longer considers cannabis to be a drug with high abuse potential and, critically, no medical value, which is where this definition falls apart for me when it relates to marijuana's current definition. In order for something to be Schedule 1, it must, by definition, have no medical value. All right? It's right in the Controlled Substances Act. Okay? For something to be Schedule 1, it must have no medical value. Okay? So saying that marijuana should be Schedule 1 seems kind of ridiculous. Because whatever you might think of marijuana, to say it has no medical value seems kind of absurd. I'd like to also kindly remind you at this point that, Oxycontin and speed in the form of Adderall and methamphetamine and cocaine are all Schedule 2. So you can actually get prescriptions for cocaine and meth and speed in the form of Adderall and all these things because they do have medical uses, okay? So is meth subject to some abuse? One would imagine. Are opiates subject to some abuse? One would imagine, but still not Schedule 1 because they have medical utility, okay? So if the cocaine and the meth have medical utility, saying marijuana doesn't seems kind of ridiculous. So it doesn't make any sense. It is illogical, and it aggravates my conservative brain because my conservative brain wants it to make sense. I want the definitions to make sense, and it doesn't make any sense. It doesn't belong in Schedule 1. It doesn't make any sense. Anyways, after completing scientific review under directive from Joe Biden, HHS is now telling DEA it believes marijuana should be placed in Schedule 3. The recommendation is not binding, and DEA has the final say, but scientific analysis posed with growing support may well mean the DEA should make the change. Also, incidentally, because the DEA is, of course, an administrative agency, Joe Biden could simply make them if he really wanted to. Because, he's the chief executive. So even if DEA doesn't want to, he could be like, how about you will? So we'll see. As a Schedule 3 drug, cannabis would, for the moment, still be federally prohibited. However, rescheduling would have major implications for research and also the ability of other people as it relates to medicine. Following Data and Science, HHS has responded to President Biden's directive and provided its scheduling recommendation for the marijuana to the DEA on August 29th. This administrative process was completed in less than 11 months, reflecting the department's cooperation and leadership to ensure a comprehensive scientific evaluation. Moving cannabis to Schedule 3 would also unlock marijuana industry tax opportunities that are currently available because it would no longer be categorically prohibited. We can confirm DEA received a letter from Department of Health and Human Services, the DEA said. As the process, HHS conducted scientific and medical evaluation. DEA has the final authority to schedule or reschedule a drug. DEA will now initial review, which again, the president could just make them because it's the DEA. And, the president controls the DEA. So, will the DEA do it? One would hope because, this is kind of stupid. It's really, really dumb. The Food and Drug Administration under HHS left the scientific review that led to the Schedule 3 recommendation. According to Bloomberg, which first reported the development, HHS Assistant Secretary, who advocated for medical cannabis before joining the Biden administration, sent a letter to the DEA about Schedule 3 recommendation. The development comes 2 months after HHS Secretary told Marijuana Movement the agency was aiming to wrap up the review. So it took 11 months, but we're there. A White House spokesman told Marijuana Movement on Wednesday the administrative process is independent, led by HHS, which, the secretary of HHS, kind of works for the president. So, there's that. And DOJ, which also is controlled by the Attorney General. And who controls the Attorney General? That's right. So the president's team will not be commenting on the agency's recommendation at this time, even though the president could totally make them if he wants to. Because, you know what if HHS says no? What if DOJ says no? Well, the president can be like, who controls HHS? The Secretary of Health and Human Services. Who controls the Secretary of Health and Human Services? I do. How about you will? No? Okay, you're fired. Get someone else too, because you have to do what I want you to. So, yeah. The White House press secretary reiterated the point during a briefing Wednesday, saying the president is asking HHS and DOJ to look at it, and it's going to be independent. So they're saying they're going to stay out of it for the moment, which, fine. They're certainly going to use evidence. It's going to be guided by the evidence, and so I'm going to leave it to HHS and DOJ to move that process, so we're not going to comment. This, of course, if one goes through, would lead to both practical and political implications. That would be very helpful. For example, for researchers, it would no longer mean they have to go through the extremely onerous process of trying to research Schedule I drugs, because Schedule I drugs are really, really restricted. So trying to get permission from the DEA to study the Schedule I drugs to find out if they have medical use is really, really hard. So it's kind of like winds up into its, sort of eating its own tail. You can't do the research to prove it has medical use, so it no longer has medical use, so you can't do the research. So and around we go. So it would make it a lot easier. The National Institute on Drug Abuse has been vocal about this, saying that Drug One puts up too many barriers. Bloomberg reported that they signed off on the recommendation for rescheduling. For the marijuana industry, reclassification would allow them to make federal tax deductions that are currently prohibited by law as it relates to the sale of Schedule I or Schedule II drugs. Because of the prohibition, the cannabis industry has faced a higher tax rate, and government have taken it upon themselves to provide tax relief. Because it's illegal, we can't do the tax deductions. Also, we can't do the banking because it relates to an illegal product. So, it would do a lot to get the boot off the neck. Politically, moving marijuana from Schedule I to Schedule III will allow the president to say that they've accomplished major reform, which I don't disagree with. It will be a pretty significant step. In case you're curious, by the way, another thing that Schedule III is steroids. And just in case you're curious where it would compare to and sort of its hierarchy, that would result in rescheduling more than 50 years after cannabis was placed on the Schedule I because it has no possible medical use, which is really, really dumb. Of course, this could also bolster movement for Congress to further reform marijuana by, changing the schedule administratively, which they have the right to do because it's in the Controlled Substances Act that says that the executive can do this. But it might also get the, Congress to, not be completely up their own ass about it. While HHS's scientific and medical evaluation is binding on DHS, the ultimate recommendation is not. So DEA has final authority to schedule the drug under the Controlled Substances Act by moving it between schedules or removing it from the schedule altogether. After considering relevant statutory and regulatory guidance and HHS's scientific and medical evaluation, DEA goes through the rulemaking process to schedule, reschedule, or deschedule a drug, which includes a period of comment. So expect to see that notice of comment pretty soon. Of course, advocates might have hoped that HHS would lead to descheduling altogether, but that seems pretty unlikely. Schedule 3 seems like a reasonable step. Not necessarily the step I'd like, but fine. You want to make it Schedule 3? Fine. So they thought maybe they'd unschedule it, but that would be one hell of a change. I mean, that's one hell of a change. To move from Schedule 1 to completely unscheduled. Oh, this is literally the most dangerous stuff that exists. It's more dangerous than cocaine, more dangerous than meth, more dangerous than speed, more dangerous than opiates, and suddenly go to how about it's literally so safe that anyone can take it at any time. That's one hell of a change. So, that was kind of unrealistic. Schedule 3, of course, doesn't necessarily make it completely free for all. It could negatively impact some state markets, with the FDA assuming more hands-on role, but how much more hands-on can it possibly get than a total ban? But the former FDA official who chaired the group and predicted HHS would make the Schedule 3 says he doesn't believe reclassification would cause FDA to approach marijuana any differently than it does now. So, the FDA will probably stay off of it for the moment. Acknowledging many industry stakeholders and advocates would rather see complete descheduling, which would be, one hell of a step. They point out the agency and Justice Department have taken a hands-off approach to the legalization movement. It would defy logic to think agencies would suddenly enforce criminalization if it's moved to a less restrictive category. So, it probably will make a lot of steps. Meanwhile, Representative Matt Gaetz pressed the DEA to expand on the recent remarks about the origin and timeline of the marijuana scheduling. Specifically, they're asking for a copy of a letter that they said the president sent the Attorney General and HHS directing the review. He also wants an update as to whether the HHS has a timetable for their work. As far as alleged research letter from Biden is concerned, an attorney filed FOIA request, but so far says they have no records. So that's where we're sitting on all of that. Thus, that brings us to some positive movement as it relates to marijuana. Uncivil law doesn't have a particular thought as to marijuana, except as so much that its current category doesn't make logical sense. And uncivil law likes things that are logical. In case you couldn't notice, there is a category called Category 1, Schedule 1. In order for something to be Schedule 1, by definition, it can have no possible medical use. It must have no medical use to be Schedule 1. It's in the definition. All right? To say marijuana has no possible medical use seems somewhat insane. That it has no medical use, particularly when you take note that they think that cocaine and meth have medical uses, but marijuana does not. That seems like a very odd conclusion to uncivil law. So uncivil law's objection to this is more in the nature of his logic brain, which doesn't really like the fact that it's in Schedule 1 because it causes an error in his mind. It's like, oh, to be Schedule 1, it must be without medical use, but it has medical use, but it's Schedule 1, and around I go. So is Schedule 3 the right answer? Don't know, but Schedule 1 isn't. So, that's fine. So the DEA is going to do whatever the hell they're doing in terms of evaluating this, I guess. At least for the moment, that brings us to the end of discussion of this story.